it was not a desktop research. When we did the performance evaluation of judges from 2009 to 2007 to 2011, it was not. Upon presentation to the Chief Justice of Nigeria, she made her now famous declaration that any judge that fails to write 4 judgments in a year will not have a place. And that seems to have changed a lot. So the pattern of the research we conduct is such. We have just finalized our work on costs for purposes of delay in administration of justice. And what were we saying? We are saying that we are positioning for punitive cost, which will be paid instantaneously and not cost in cost. If we do that, it becomes punitive, and it will help people to shy away from unnecessary adjournment. And if we shy away from unnecessary adjournment, automatically we'll find that cases will flow better. And we are equally suggesting that to a very large extent, the court will make it in such a way that it is not even the client that will pay, because you are representing the client. You are the lawyer. The lawyer should pay.
Should bear the cost.
The lawyer should bear the cost. Without prejudice and with the greatest respect, lawyers are critical partners in the delay of the administration of justice, one way or the other. We all claim that we are in the temple of justice, and we all worship in the temple of justice. But in that temple, more often than not, you find out that rules are honored more in the breach than in observance, with the greatest respect, and that is the truth. Come the day that all lawyers will rise in unison to bid farewell to delay in administration of justice, not from an individual perspective, but from a holistic position, viewing things the way they should be, that this is not good for our system. And then being in a position to say that if you are labeled for doing some of these things, it is enough to even push you to the disciplinary committee, because you are no longer worshiping as a minister in the temple of justice. You are more or less an agent of desecration of the temple of justice. And that on its own is enough for you also to be charged for disciplinary actions in the disciplinary committee. So when we become so hard on ourselves, so many things will give. One, it will impact on the way we advise our clients. Most lawyers misadvise clients just because they want to get briefs and make money out of it, knowing fully well that in the fullness of time, nothing fruitful will come out of it. That also is wrong. That is fraudulent on its own, on the face of it, when you misadvise somebody deliberately because you want to benefit from it. So these are all the issues that we seem to be putting together. Of course, you know, we are working hard on the issue of unification of both the criminal law and the penal code. And for now, the greatest work we are doing now is on how we can formulate a hybrid between the adversarial system, which is the system we practice in Nigeria, which we inherited from the British, and the inquisitorial system, which is what is obtainable in the civil law. We are also saying, and we are strongly of the view, that our own notion of justice, our concept of justice, from all indication, does not seem to stand the test of time anymore. For obvious reason, we have passed the time that we should be saying that judges should not descend into the arena when the need arises, because that is a throwback of the adversarial system. But the inquisitorial system will say no, that in the search of truth and in the search of justice, judges can descend into the arena. We do not want their eyes to be covered by the dust of conflict. Here, to an extent, we don't want their eyes to be, if their eyes are even covered, they cannot see anything, talk less. But again, are they even supposed to see? They are supposed to be blindfolded. But figuratively speaking, yes, they should not allow their eyes to be covered by the dust of conflict. But that should also not prevent them from seeking to see the truth wherever the truth is, even if they are blindfolded. So if it is important for a judge to mention a case that he is aware of, that the two parties have refused to mention, but he knows fully well that that case will impact positively on the turnout of the case, and he keeps quiet because he does not want his eyes to be covered by the dust of conflict, we are saying that that time is gone. We must seek the truth as scholars, but also judges must seek the truth and seek justice at the end of the day. And if the adversarial system has been an impediment it is time we say bye-bye to that aspect of adversarial system. And then we can now incorporate the aspect of the inquisitorial system that obtains in the civil law countries, which we feel also is better than that which says that judges should not descend into the arena, and merge them to form a hybrid in our system of administration of justice. That also can help us. So we should get out of extreme conservatism and look for the future of law and the administration of justice in our country, and see how we can take those things that are working exceptionally well in other clients and see how we can incorporate them. So there should be no hard and fast rule.
Our interview segment and the program for this week, you can watch it again by logging into www.youtube.com/channelsweb. You'll also find past episodes of the program there. Feel free to send me your comments or questions. You can reach me via email or Facebook. And of course, follow me on Twitter. I am Shola Sheyeli. Thank you for watching.